All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All we have cause to plead, draw near. Give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Jackson versus Household Finance Corporation. Counsel.
May it please the Court. Good morning, Your Honors. My name is Nicole Ziegler. I'm here on behalf of the petitioners, Cynthia and Thomas Jackson. The Jacksons are seated in the audience. They've traveled here from Tampa to join us today. We appreciate your time this morning. Your Honors, I'll give you a brief background if you'd like the facts. I think it's a very simple matter. It stems from a foreclosure case. The heart of the issue is how the second DCA in the trial court applied the business records exception to admit business records into this case. The most pertinent facts have to deal with the testimony of the respondent, Household Finance Corporation III, I'll refer to them as Household, how Household's witness testified to admit the business records that were required in order for Household to establish a prima facie case. As referred in the briefs and in the record, on direct, the witness for Household testified that he was an assistant vice president of HSBC. Not Household, HSBC. He also testified...
Let me ask you this. You did not raise at trial any objection to the fact that Household was a wholly owned subsidiary of HBSC, did you?
Your Honor, I think that the facts of the case don't actually reflect exactly what Household's relationship is to HSBC. The only evidence that came in was that... The
question was there an objection that because these are Household's documents, this witness is not qualified to testify as to the record keeping of those documents?
Yes, Your Honor. Immediately...
Where is that in the record?
Yes. Immediately after the witness's direct testimony, the Jackson's attorney objected that the witness was not qualified and didn't lay a proper foundation based on a lack of personal knowledge. And I have that cite here for Your Honor.
And it would be your belief that that was a specific enough objection to raise the issue that you're raising now, which is that it was a different company's documents?
Yes, and that's one of the arguments. There are actually two arguments, Your Honor. It's specifically because the witness isn't qualified. There's not a foundation. And that's because both, you have records coming in from both Household and HSBC, but also it goes specifically to the fact that this witness didn't even demonstrate that he was qualified to lay the foundation for the HSBC records. He testified that he's an assistant vice president. We don't know what he's the assistant vice president of. He didn't give any description of what his job duties or responsibilities are. He didn't give any explanation that he's ever done anything.
Isn't your responsibility then to impeach him? If you believe that he is not qualified?
No, Your Honor, not in this case and not the way that it developed. The way that 90.8036 is written is that the record proponent has to establish the four foundational elements through a qualified witness. Then and only then does the burden shift to the opponent to attempt to impeach the witness or otherwise demonstrate that the records were untrustworthy. In this case, you never get to the burden shift because the witness never demonstrated that he was qualified.
The witness you're talking about, is that Mr. Bursch?
That is Mr. Bursch, Your Honor. You're correct.
Didn't he say that he was familiar with HSBC's business practice and had access to the Jackson's mortgage loan account? Isn't that sufficient?
He did, Your Honor, and I would submit that that's not sufficient. It doesn't tell us that he actually knows anything about the things that he's testifying to. How is he qualified? How can the court judge that he was qualified to say yes to those things?
But it seems like to me you're just suggesting some kind of amorphous requirement of more. And you fail to point the trial judge to a specific deficiency. And I understand you raised this general objection, but I'm trying to look at it from the perspective of the trial judge. What's the trial judge to think? What specifically is missing here? And you don't really identify what is missing or what more should be there, it seems to me. I mean, the question's asked, did HSBC prepare and maintain these records with respect to the subject loan? He says yes. I mean, it's sort of necessarily inherent in that he has knowledge of that and these other things he testifies to. So I'm trying to understand how, and this is basically the same point that in question that Justice Lawson made. I'm trying to understand how the trial judge can be in a position to abuse discretion on this when you've not really directed the trial judge to something that would help the trial judge understand why specifically what has been presented is not sufficient. So what am I missing?
Understood, Your Honor. And I'll direct the court to the record at page 209. That's specifically where the objection is raised. And the objection was phrased, Your Honor, my only objection is that this is hearsay, that this witness hasn't laid a foundation upon which to testify as to these business records or to authenticate any of these documents based on personal knowledge. This is a hearsay objection because this is a hearsay exception to admit these records. I think the objection directly put the court on notice that the defendants felt that this witness wasn't qualified, that this witness didn't satisfy the hearsay objection because these are hearsay records. There's no testimony before the court to demonstrate that this witness had the knowledge to attest to the things that he was testifying. How do we know that he knows that these records are
Isn't the rationale for the rule, though, that the records are inherently reliable when those elements are met, that they're kept in the ordinary course, made near the time of the event, et cetera? And it seems like someone in his position who's been with the company for 25 years, which only came out on cross, and has had these different jobs, it seems like he clearly is qualified to testify as to the elements that are specifically laid out in the statute. I mean, isn't that what this is about?
I think that is what this is about, but I would characterize it differently, Your Honor. Being an employee for 25 years doesn't mean that Mr. Bursch had anything to do with the activities that underlie these documents, or that he had any knowledge about how these documents are created, or any knowledge about the fact of whether the activities and the manner of creating these records were done in any reliable way. These are hearsay. They are inherently unreliable, and unless you have a qualified witness to put on those four testimonial elements, you don't ever place that reliability back into the documents. They are inherently unreliable, otherwise they would be an exception to they wouldn't be hearsay. They're an exception, and this court has previously held that an exception has to be strictly complied with. I don't know how there can be strict compliance when there's nothing to show the court that this witness has the knowledge to testify to the things that he's saying.
It seems like you're mixing issues. One issue is, once you have, is the witness qualified to testify about the things that the witness is testifying to, correct?
Correct.
And then the second issue is, what's the foundation that's required? What things have to be testified to in order to establish that these are business records after you get the qualified witness? Those are separate inquiries, correct?
Those are separate requirements.
And the strictness requirement has to do with the things that need to be testified to, correct?
I think it goes to both, Your Honor.
Where in the law would you find authority for that?
Well, this court has previously ruled in the cases, I believe it's the Israel case, that hearsay exceptions have to be strictly complied with. That applies to the whole exception. We can't parse out parts of the exception.
Okay, but with the qualification of the witness, aren't we really talking about Section 901 of the Code and authenticity?
I think it's both, Your Honor.
Okay, well, I mean, when you're talking about a document, Section 901 says that you have to put on a prima facie case that the document is what it purports to be, correct?
Correct.
And here we're talking about it purports to be a business record, correct?
Correct.
So we have to have a witness with sufficient knowledge to testify that this, in fact, is a business record, and nothing more. I mean, so that the qualifications related to really 901.
I think I agree with that in part, Your Honor, but I do think that the two rules intersect and they interplay with
Well,
each
I mean,
other.
once you get a witness that's qualified to testify that this does meet 901, that this is what it purports to be, it is a business record, then that witness can go testify to the 8036 requirements, correct?
Correct, but we don't have a witness that has the knowledge to testify that this is what it is.
Let me ask you this. If the witness came in and said, I was employed 2 weeks ago as a records custodian, I'm paid minimum wage for that job, and I have had a week of training about the complete records keeping system, I have been trained, and then I've had a week of work with that system. So I know exactly how it works because I was trained as to when the records are put in. I can testify to every piece of the foundation based on my training and my full week of experience with that system. I've pulled these documents, I've compared them to the electronic records, as this witness testified to, and these are, and then would that witness be qualified?
Yes.
Okay.
And the key difference is that under your scenario, the witness has had training on how these records are created.
Here you have a witness that says, I was a vice president. I have worked with the record-keeping system for 25 years in my various capacities, managing departments of the company. If a 2-week clerical employee can meet the requirement to have sufficient knowledge as to how they keep records, it just is sort of difficult to understand the argument that a 25-year high-level employee that's managed various departments and says that he can testify to these things is not sufficient to make a simple prima facie case that he can say that these documents are what they purport to be, they're business records of the company that I've worked for 25 years.
Well, Your Honor, he testified that he worked there for 25 years. He didn't say in what capacity other than to generally say a vice president. Vice president of what? He doesn't testify that he has anything to do with these records. He went and looked at records in the system. You can look to federal cases for some support on this issue that say that just being able to go look at documents or even pull documents isn't sufficient. That doesn't give the witness the qualification necessary. And I've cited that in the brief.
What you're saying is that even though he worked there for 25 years, he was not sufficiently in the weeds.
Yes.
To know how these records are kept.
Yes, Your Honor, because and it's important.
How is that possible?
I'm sorry?
How is that possible?
What if he worked there for 25 years in marketing? Does that give him any qualification to testify that these business records relating to loan documentation and payments and things of that nature are accurate or are kept in the regular course of business? This is a bank. They have who knows how many vice presidents. He may have never done anything other than go look at some records.
I guess back to Justice Lagoa's point, wouldn't you agree that all that the proponent of the evidence has to do is establish a prima facie case, first that the person is qualified to testify, and then get to the and then wouldn't the burden shift to you to inquire as to these things?
No, Your Honor, because that is part of the initial foundational burden under the rule for the record proponent. The record proponent has to have a qualified witness.
Where do you find that in the rule itself?
That's the way that the rule is written. The rule says that the record proponent has to show these 4 elements and that it has to do so through a qualified witness. Under the scenario that you just proposed.
The rule only says the proponent must show, 1, the record was made at or near the time of the event, right?
Correct.
So you can just testify, do you have knowledge that this was made at the time of the event? Yes. Was made by or from information transmitted by a person with knowledge. So you don't have to have personal knowledge, you just have to know that someone did that with knowledge.
Correct.
Next thing, was kept in the ordinary course of a regularly conducted business activity. And 4, that it was the regular practice of that business to make such a record. That is it. That is the prima facie element that you have to meet. Then it shifts to the other side, and you have the ability to impeach, or you can, of course, do a deposition beforehand and depose the person who's going to testify at trial with the most knowledge.
You're absolutely right, Your Honor, but even in the way that you just read the rule, the witness was saying that he had the knowledge to say those things. We don't know that this witness has the knowledge to say the things that he's saying. Now, I think the more important issue here...
Well, he purports to have the knowledge. I mean, it's implicit. It's just all kind of rolled together. And it seems like I'm still struggling with why you don't have an obligation to point out specifically what more needed to be said.
I think that what more needed to be said was facts that demonstrate that he actually possesses the knowledge to say these things. So if you look at the Lassonde case and you look at the Pinpon case, they give an example of what a qualified witness would be. The cases kind of generally have evolved to say that it's someone well acquainted enough with the records. We don't know that this witness has any acquaintanceship with these records. And those two cases actually go on to kind of give a better example, a more specific example, and say that it is somebody who is in charge of the activity that's underlying these records, or is somebody who, by the very nature of their job responsibilities and training, has knowledge and familiarity with these records. We don't know anything about this witness.
As part of the foundation, wasn't this witness asked what he did to authenticate these records? He said that he pulled them, he reviewed them, he used the system, the record-keeping system, to look at them and compare them electronically so that he could testify that these were in fact accurate copies of the documents that were reflected in the record-keeping system of the company that he's worked for 25 years.
He did say that he looked at them in the system, but I would submit, Your Honor, under the federal authority, that's not sufficient. Just being able to go look at something doesn't tell you that they know anything about how the records were created. And
but he did test, before he got to the elements, he did testify generally that he was familiar with the record-keeping and business practices of the company. And then as Chief Justice Kennedy was pointing out, when your side had the opportunity to probe what he knew, nothing specific came out. In fact, if anything, he seemed more credible after that. I mean, so if you're the trial judge, what are you supposed to do with that?
Well, on cross, and bear in mind, the records have already been admitted at this point. So they didn't even have a chance to go ahead and test the sufficiency. They were already in. But even on cross, when they asked how he had this knowledge and familiarity, it was all generalities. I've had cross training. I've worked in various departments. That was the moment for him to say what he actually possessed to testify. He didn't give any specifics. We don't know anything about him. And even more fundamentally in this case, I think it's important to remember that this was an HSBC witness. And this is a witness that's trying to admit records that include records from household. You can admit records from one business. One witness can admit records from another business, but they actually have to take it a step further. They have to do the 4 elements, and they have to testify how they verified the accuracy of the records of the prior business.
But didn't he testify that HSBC prepared and maintained these records with respect to the subject loan?
He did testify, Your Honor, but if you look at the records themselves, they contradict that. They have household's stamp on top of them, and if you look at...
It is a matter of common knowledge that someone servicing loans might have paperwork that has the name of the entity for which the loan's being serviced. But again, none of this is raised. Let me ask you a question about the standard review here. You assert, if I recall correctly, that the standard review is de novo. Is that correct?
That's correct, Your Honor.
Now, and then you argue that really the kind of core issue here is whether the person testifying was well enough acquainted, correct?
Correct.
Okay, is well enough acquainted a factual or a question of law?
I think in this case it was a question of the law because it has to do with the shifting of the burden.
That's what I wanted to ask. You are well into your rebuttal time. I will give you an additional 2 minutes since we helped you run it up.
Good morning, Justices. May it please the Court. My name is Matthew Sissio, and I represent the respondent in this matter, Household Finance Corporation III. As Justice Lagoa pointed out, the statute 90.8036, as written, exempts hearsay if the document that is going to be introduced is made at or near the time of the event by someone with knowledge, kept in the ordinary course of business, and it's a regular practice of that business to make such a record. That's all the statute requires. Those are the four elements needed, and those four elements were met in the Jackson case. Now, after those four elements are recited in the code, it goes on to say the business records are admissible unless is the key word, because that is where this court in Love v. Garcia switches the burden. So those four elements are met, and then the business records are admissible unless there's other indicia of untrustworthiness. And then it becomes incumbent upon the opponent of the entry of these documents to establish that there's something unreliable, untrustworthy, something about these documents that they shouldn't be admitted into evidence, and that is their burden now, to impeach, to cross-examine.
Were all of these records coming from HSBC?
These are all HSBC records because HSBC had acquired Household in 2003.
Household Finance Corporation III?
Yes.
Okay, in the transcript, it refers to a Securities and Exchange Commission Form 8, a merger announcement. Nowhere in that could I find mention of Household Finance Corporation III. Did I miss it somewhere?
No, you didn't, and that was the evidence that was introduced. However, that is more of a standing issue, as Petitioner's counsel brought up at the beginning of her argument, which was completely waived, never brought up at the trial.
So what is the relationship between HSBC and Household Finance Corporation III?
Household Finance Corporation III was acquired in 2003 by Household. The document introduced...
In part? In whole? How?
In whole.
Where is that in the record anywhere?
The testimony. In the testimony.
Where in the testimony is that?
Do you mind if I just get to the
Please.
record for a second? It's lines 1 through 3, page 8 of the trial transcript. This is an answer from the witness David Birch. This is the merger announcement, which indicates that HSBC purchased Household Finance Corporation III.
But in fact, the announcement has no mention of Household Finance Corporation III.
Not with the Roman numeral, but this is uncontroverted testimony. There's no objection here, nothing to show anything to the nothing contradicts this throughout the whole trial.
So all of the records testified to are from HSBC.
They are HSBC records that both, actually on the evidence, have HSBC's logo and Household's logo together as one, because HSBC is the parent corporation, and I believe that's in the merger document.
Who originated the law?
Household in 2006.
Household Finance Corporation III.
Finance Corporation III as a subsidiary to HSBC.
So they originated the loan. The note and the mortgage originated by Finance Corporation III. Those documents are part of this composite exhibit.
That is correct.
And so those were originated by Finance Corporation III.
The original loan documents, the note and the mortgage, but those to me aren't even an issue of business records, because they would come in as self-authenticating under 90.902 Florida statute, because one's a publicly recorded document and the other is a UCC negotiable instrument.
How did they get into the records of HSBC and when?
I'm sorry, Justice.
The testimony is those documents are part of the ordinary course of business records of HSBC in this composite exhibit. How did they get there?
Into HSBC's business records? Yes. HSBC and Household Finance Corp are the same. It's a parent and a subsidiary. They use the same systems. They keep the same records. They're one and the same. There's no difference. This isn't like a service release.
There's no service agreement?
Not in the record. There's no servicing agreement. That was never an issue, and that wasn't required for the plaintiff's prima facie case here to establish foreclosure.
So you're asking us to legally treat them the same with no distinction?
That was established at the trial, uncontroverted testimony, never raised as a standing issue. Not even in the answer in affirmative defense did they raise that issue.
Well, it does seem to me to be incumbent upon you to put on some level of minimal foundational evidence, as your opponent suggests. I mean, here's documents presented as loan history, right? Who generated the loan history? Is it Finance Corporation III or HSBC?
Household Finance Corporation III is the entity that generated that payment history, but they did so as a subsidiary of the parent corporation, HSBC, because they are the same for all purposes of records, record keeping. They are not different entities.
So the loan history itself is a Finance Corporation III document.
Both logos for Household and HSBC appear on that document. There was no testimony from either side as to specifically whether the household originated these or HSBC did. But again,
I'm a
they're
little
the same.
confused. You got to help me. With the loan history,
Yes.
is that a Finance Corporation III document, or is it HSBC, or you're saying it's both?
Both.
There is some testimony, isn't there, on page 7, right before that? In fact, the question right before the one you just cited. It's asked, did HSBC prepare and maintain these records with respect to the subject loan? In other words, which is the entity that prepared and maintained these records? And is it HSBC? And the answer is?
HSBC, yes. So that's correct. And that's throughout all the business records testimony. They infer that they're HSBC records, but at the same time, they are also household records. They're the same for the purposes of whose records they are.
So once a loan was originated, it went into the loan servicing history accounts of the HSBC, which is the same as Finance Corporation III. There are no separate records kept. There's no separate distinction between who keeps what records. For all purposes, Household Finance Corporation III should be considered the same as HSBC.
That is what the record shows, and that's why when this court made the decision or wrote their opinion in Love v. Garcia in 1994, which has been followed by most of the DCAs, the defense counsel should have asked these same questions.
Well, all it would have taken is one question and answer from your client here to put that up into a foundational presentation, and maybe we wouldn't be here.
But that's the thing, how far do you go? As Justice Kennedy mentioned, it's an amorphous standard that
Well,
they're looking for.
it seems not too
this.
amorphous to me, at least, to say, here's an entity that is totally different entity from the plaintiff seeking to foreclose the mortgage, and waving a computer printout around saying this somehow relates to this particular borrower, but there's no establishment in the record of what the relationship between the entity that generated the computer printout and the plaintiff, nor the employee, or any discussion about how that relationship works. It seems like not too much to ask to either establish really what the relationship in a corporate way is, or to show that there is some kind of servicing agreement, which I guess there's not.
Well, they did present the acquisition agreement from the SEC. It did not have the. It did not have
There's
the
no
Roman
mention.
numeral-
There's no mention of the company in there anywhere. The plaintiff is not in there.
I
Is it
understand.
not?
With the Roman numeral III, it is not. But again, Your Honor, that is a standing question. I don't think that goes to the records here.
It goes to the relationship, it seems to me, between who's testifying, putting these business records on, and the plaintiff.
An HSBC representative who works for the parent company, and these records are both records of the subsidiary and HSBC.
Where does it say that?
That these are household records?
Yes.
On the face of the evidence.
Well, it was testified that they're HSBC records.
And they are. They're both HSBC and Household. And on the face of the evidence, it has each logo. Household Finance Corp III. I think it says HFC3, Roman numeral 3. And then
So we're supposed to read that into the business record hearsay exception from the logo. That's how this works? We're to gain confidence of a hearsay exception on the business record exception by the logo.
in itself, that is not enough. But you have to take, and the judge did so in his discretion, everything in the totality of the evidence and the testimony, and there was absolutely nothing except maybe for the little fact you're pointing out now that the Roman numeral 3 was not in the merger
not a little fact to me.
No one pointed that out, Your Honor. That the judge may not have even been aware of that because defense counsel sat on their hands here. So, and that's why it was several counsels removed at the trial level several years ago.
And the judge said overruled.
They objected foundation, and that has been case law throughout this DCA's and the Supreme Court, that just an objection on foundation is insufficient. You have to specify your objection, Your Honor.
Okay.
And specifically, this court here, when I was discussing Love versus Garcia, they compare the admissibility of the business records to a mini trial. The 4 elements are needed to shift the burden to the opponents of the records that would be the proponent's prima facie case. So in essence, and this goes back to the standard of review, de novo, or abuse of discretion, if you consider the admissibility of business records in the sense of a mini trial, upon laying the foundation, that's the prima facie case, just like anything, negligence, duty, breach, causation, damages here, 1, 2, 3, 4 in 90.8036. Once that foundation is laid, there's nothing else that needs to be done. It is now the defendant's job, or the opponent of the documents, to impeach the witness, and that's what happened in Maslach. And Maslach is the case that is currently before this court on conflict. That's from the 4th DCA. And the difference between Maslach and Jackson, and I argued this in my jurisdictional briefs, is that Maslach did have testimony that was negative or that could have been deemed unreliable, and within the judge's discretion, yes, it would be reasonable to say there's some questions here. For example, a witness in Maslach stated she never worked in the loan payment history department. Compare that to our case, where all we have is I worked there 25 years, I worked in various departments, and I actually went in to the system myself and pulled these documents prior to trial. If he was not familiar, this is the Jackson witness, how would he have the ability to go into the system himself?
Well, somebody could be sitting there telling him how, or you could be reading instructions. Why wasn't there testimony to indicate that, yeah, I've worked with this system. This is our system to service loans. I had some connection with supervisory responsibilities over our loan department. This is how the payments come in. This is how it's reflected. This is subject to review by our internal audit and auditors, and there's some degree of reliability here. I'm not looking for necessarily a detailed flow chart based upon personal knowledge of how this software and the whole process works, but it does seem like that there should be some minimal connection between this particular employee and these records.
If there was more testimony like that, it would have been great, and we may not be here today, Your Honor, but it's not required.
The question is, isn't it required?
It is not required. And that's right from the statute and right from how this court has set precedent in Love versus Garcia, and that's traveled over to criminal cases. This court's decision in Baber versus State from 2000, where it was certified to this court to see if that same burden shift should apply from civil cases and criminal cases. And this court answered affirmatively, yes, it should. And so across the board now, this burden shifting of the business records exception until something is done in the code and legislature changes it.
So can they bring in a receptionist or any position whatsoever, someone in sales who has no responsibilities, no supervisory responsibilities over the loan application, has nothing to do with loans whatsoever, to simply compare these, to come and testify, yeah, I worked at the company for 25 years, and these two things compare. Is that good enough? It seems like that's what happened here.
Well, I would say he was more than a receptionist, Mr. Bursch. He was an assistant vice
No,
president.
I use that as an example. I'm not saying that this person is in that capacity. I'm just using it as an example. Is that okay?
Yes, Justice Polson, it is. If a receptionist comes in and testifies under penalty of perjury that the documents are made by someone with knowledge, they're made in the regular practice of my company's business. It's the regular business or the regular practice of my business to make these records. And there's nothing to the contrary. The defense counsel doesn't know.
Wouldn't that secretary also have to first testify that I'm familiar with the business practices of the company, as the witness did here? I mean, there has to be some kind of testimony that I'm familiar with.
The statute doesn't exactly say that, but yes, more is helpful, and I'm glad Mr. Bursch here did say he was familiar.
You're right, he doesn't say that. That seems to me to be the problem.
No, he does. In the transcript, he says, I'm familiar with the record system.
But not these records of how they relate to the loan history and so forth, does he?
Yes, Your Honor.
Okay, help me out. Where does he say that?
This is lines 9 through 13, page 6 of the trial transcript. So you are familiar with the business practices of HSBC? Yes, I am. And it is the regular business practice of HSBC to record acts, transactions, payments, communications, escrow account activity, disbursements, events, and analysis with respect to the mortgage loan account. Yes, it is. And even if you go before that, on page 5, and are you familiar with the business practices of HSBC? Yes, and then there's an objection, and then it's the yes, I am answer. So yes, he does say he's familiar with the business practices of HSBC. And by answering the 4 questions, again, under penalty of perjury, without any impeachment or any reason to not believe this, this gentleman here, they're all answered in the affirmative. That's sufficient. That in itself is sufficient. Now, had defense counsel said or asked some of the questions you've asked me today, maybe within the judge's discretion, he could have found some unreliability. But without that before the judge, it would have been unreasonable to not allow these records. We discussed the Federal Evidence Code earlier, how it's only persuasive authority, but the code has been rewritten or revised in 2014. It specifically says, unlike our current evidence rules, which just says unless there's some indicia of untrustworthiness, it says unless the opponent shows some indicia of trustworthiness. So even the federal courts have revised their code to show that it's incumbent upon the opposing party. So they've clarified that, and for consistency, I would suggest that, or I would believe that our counterpart was meant to be similar in that respect to the federal counterpart. And one more thing, if this court were to rule that the business records should not have been admitted, the proper remand would be for an evidentiary hearing for the plaintiff to prove its damages, and I believe all 5 of the DCAs are on board with that, and there is a recent case that came out after this Jackson opinion. It's Sacks, S-A-C-K-S. I don't have the citation on me, but it's from the 4th, and exact situation as we have here, where they did not allow for the introduction of the business records at the DCA level, but the remedy was remand for the plaintiff to go back and assess or prove those damages at an evidentiary hearing. Thank you, Your Honors.
Thank you, Your Honor. Justice Poulson, I think you hit the nail on the head. The issue here primarily has to deal with the fact that the payment log, which is a necessary component to Household's case, is from Household. It's not from HSBC. The plaintiff, Household...
Did you point that out to the trial court?
Did
you make that specific objection to the trial court?
I think it is a specific objection because it says you didn't lay a foundation. You don't have a witness with knowledge.
I asked you a question.
Yes.
Did you make that specific objection, raise that specific point with the trial court? That's a clear question. Can you answer that?
The defense attorney did not specifically say to the court, Your Honor, this is a household record, not an HSBC record. He did not. But he did object that there was a lack of foundation. So to your point, he did not specifically say that. But there are a lot of assumptions being asked of you to make here. You're being told that this is a parent and subsidiary, but we don't have anything that shows that. The Form 8 that Justice Polson was referencing doesn't even mention household finance. It mentions household international.
Do you agree with the remedy?
Do I
that
agree
he-
with the
that
remedy?
you're-
No, I don't agree with the remedy. And their support for that, the first DCA in Burdishaw versus Bank of New York Mellon, as well as the second DCA in Wolkoff versus American Home Mortgage, pointed out that appellate courts don't generally provide for a second chance to put on proofs that you should have done the first time. Household had plenty of opportunity to come and bring a qualified witness and put on a prima facie case, and it didn't do it. So now it wants to go have a second bite at the apple to do what it could have done in the first place.
What is the remedy?
The remedy should be a reversal for an involuntary dismissal for failure to meet the prima facie case. They
And then
didn't put on proof of damages.
They could bring the foreclosure again, right? If appropriate.
If appropriate, they could, if appropriate. I see that I only have a couple seconds left here, Your Honor, but we appreciate you taking the time today, and I understand that this is a complicated issue in the sense that there are questions as to how this standard should be applied, and I think that's part of why it is a de novo review in this case, because it has to deal with the application of the rule. And I think that there is some crossover into, do you get into an abuse of discretion? So I acknowledge that, but I think on the facts of this case, it would have been an abuse of discretion because this fundamental, elemental document was never properly brought in. So there was no proof of damages, and there could be no prima facie case. Thank you, Your Honors.
Right. We thank you both for your arguments.